Welcome back. You're watching Rewind 2021. The year will also be known as the year the RBI cracked the whip against defaulting NBFCs like Reliance Capital and the SREI Group, sending them to the bankruptcy tribunal for resolution. It was also the year that saw the first financial services company being resolved under the IBC, that's DHFL. And finally, some light at the end of the tunnel for depositors of crisis-stricken PMC Bank. Ritu Singh wraps up all the action.
Never before has the country faced the collapse of 7 financial institutions in under 3 years, 2 of them this year alone. One might expect this to trigger a financial stability crisis for the country, but the regulator's strong action came to the rescue. Diwan Housing Finance Limited became the first ever financial services firm to be resolved under India's 5-year-old bankruptcy law, setting the precedent for resolution of other stressed financial companies.
The successful resolution of DHFL has created a nice template that you're seeing already being replicated by many other institutions as they go through the bankruptcy process.
Soon after Piramal Group announced the closure of the DHFL deal, Reserve Bank of India moved to supersede the board of 2 SREI Group companies and appoint an administrator in early October. SREI Equipment Finance and SREI Infrastructure Finance together have a debt of over 32,000 crores and had defaulted on more than 14,000 crores of those loans when RBI took action against them for non-repayment of dues and governance concerns. Both the firms are currently undergoing insolvency proceedings under the NCLT. While banks were able to recover almost 46% of their dues with the resolution of DHFL, they're hopeful SREI could also fetch a decent value.
There is some precedent now. We have the example of DHFL, and RBI referred it to the IBC. And here we do know that, for example, the equipment piece is better than the infra piece. So obviously there could be some juice in the assets.
With SREI, RBI's move was largely anticipated. There were signs of trouble brewing and murmurs on the street about RBI taking action. But no one expected RBI's takeover of Reliance Capital next, barely 2 months after SREI was superseded. On November 29th, RBI said it took action against Reliance Capital in view of defaults and serious governance concerns. As per its FY21 annual report, Reliance Capital had already defaulted on repayment of loans totaling over 20,000 crores, and its total financial liabilities stood at over 20,800 odd crores. While SREI and Reliance Capital face a long road ahead before resolution, there is light at the end of the tunnel for depositors of PMC Bank. 2 years after the cooperative bank was placed under restrictions following the unearthing of a fraud, RBI has proposed a draft scheme for its amalgamation with Unity Small Finance Bank, a joint venture between Centrum Finance and Bharat Pay. While depositors with up to 5 lakhs in deposits are assured to get their money immediately, those with higher deposits will get their money back over a period of 3 to 10 years. The final scheme is still awaited.
As per law, the final scheme as finalized by us, depending on the inputs, we will examine them. Based on the comments we receive, we will examine them and we will finalize the scheme. And then we will have to, as per law, we have to send it to the government for approval. So we propose to do it very quickly.
Though the Rescue Act reveals the regulator's proactive hand, the criticism, however, is that perhaps RBI waited a tad too long before stepping in. Going ahead, resolutions of both SREI and Reliance Capital are going to be very keenly watched to ascertain if DHFL was not an exception and if the IBC can serve as a good tool for recovery of distressed non-bank lenders. 2021 is going to go down as the year that saw the cleanup of the last set of legacy distressed financial assets, and now, with a prompt corrective action framework for NBFCs in place, one hopes that large dissolutions like IL&FS and SREI can be averted in time. In Mumbai, Ritu Singh.
While the Supreme Court has also had a busy 2021 with policy-making, defense of fundamental rights and tough corporate battles, only some of the things on the court's agenda. Ashma joins us now to round up a few of the Apex Court's most important judgments in the year gone by.
The Supreme Court was constantly among the headlines in 2021, sometimes too much for the liking of the latest Chief Justice. However, there's no denying the extent of impact that the top court has had on policy making, defense of fundamental rights, and tightly wound corporate battle. Here's a recap of the top 5 rulings and orders from the Apex Court. First up, the vaccination drive. Now, the milestone of 100 crore doses that India recently celebrated could well go back to this single order of the top court coming in on May 31st. Now, prior to May 31st, Centre had put the onus on the states to procure half the vaccines. The half that was procured by the states was bought at prices higher than those offered to the Centre. The Centre's drive focused primarily on those above 45 years of age, and it also required mandatory COVID registration. Now, in its May 31st order, the Supreme Court slammed the government policy as being arbitrary, asking for the government to wake up and smell the coffee and to review this existing policy. Now, the Supreme Court questioned why states were being asked to procure at higher prices. The Supreme Court asked the Centre to consider buying from the vaccine manufacturers as a single monopolistic buyer. The Supreme Court also cited digital divide and questioned mandatory COVID registration. And as if on cue, exactly 1 week later on June 7th, the Prime Minister announced the new vaccination policy. Now, the second major case before the top court was that of Pegasus. Now, findings by an international consortium of journalists discovered the use of an Israeli spyware Pegasus to target various Indians. Now, the report claimed that government ministers, opposition leaders, senior bureaucrats, journalists, activists, and even Supreme Court judges had been snooped upon. Now, a batch of petitions led by the one filed by senior journalist N. Ram moved the top court to seek a probe. Now, just as in the parliament, the government refused to either confirm or deny the procurement or use of Pegasus spyware. Instead, the Centre asked for a government-appointed panel to probe these allegations against the government. Now, the Supreme Court rejected this proposal by the Centre, noting that the Centre itself is facing these allegations. The Supreme Court frowned on the repeated use of national security bogey to silence questions coming in from the judiciary. The Supreme Court also held that it will not cower away from defence of fundamental rights and proceeded to appoint a judicial committee to find out if the government indeed had been illegally snooping on its own citizens. Now, the Supreme Court's presence was needed perhaps the most during the farm laws protests. It was an unprecedented situation where the national capital was surrounded on its borders by lakhs and lakhs of farmers. Now, after the government failed to make headway with the farmers, the Supreme Court intervened and restored some sense of calm. The Supreme Court stayed the operation of the 3 farm laws in question. The Supreme Court called the stay an extraordinary one, terming it as an achievement of the protests. However, the court also warned that the stay was not an indefinite one and that farmers must come to the table to talk. Now, the fourth case on our list is a corporate battle, the one for the ages, the Tata versus Mistry dispute. It all began in October 2016 when Tata Sons removed Cyrus Mistry as the chairman of Tata Sons and as the heir apparent of Shapoorji Pallonji Group, and also as the sizable shareholder in Tata Sons. Cyrus Mistry launched a scathing attack on Tata Sons and Ratan Tata himself. In fact, in December 2019, the NCLAT had reinstated Cyrus Mistry as the chairperson. Now, challenges were issued and found their way to the top court, and in March of 2021, the Supreme Court settled this ugly spat between the two corporate titans by ruling in favor of Tata Sons. The Supreme Court set aside the NCLAT order that reinstated Cyrus Mistry. The Supreme Court also held that there has been no oppression or mismanagement. Ratan Tata called it a vindication of Tata Sons' values and ethics. Number 5 on our list is the infamous AGR case. Facing a combined demand of over 1 lakh crore rupees, Bharti and VAI had moved the top court to recompute the demand raised against them. The alleged double counting of income and various arithmetic errors. The Supreme Court, however, was not impressed and upheld its earlier order, reinforcing the demand. This order came despite the industry pleading for its very survival. The Supreme Court, however, would not have any of it. This in turn prompted a relief package from the DoT, and that's not all. We hear that there is another round of reliefs, Relief 2.0 for the telcos on its way. So those are our top 5 decisions of 2021. Let us know what you think.
Well, that is Ashmit's curation of the top 5 judgments from the Supreme Court that had an impact on policy making. With that, it is time for us to wrap up this edition of Rewind 2021. But stay tuned to CNBC TV 18. The news will continue. We'll see you after this break.